I now declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill 2024. I acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I'd also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. For those joining online, I'm Senator Green, Chair of the committee. With me today via video conference is Deputy Chair Senator Scarr. Senators Polly and Senator Shoebridge will also be joining us. I remind witnesses that in giving evidence to the committee, they're protected by parliamentary privilege, and it's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretary as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that an answer be given in camera. Such a request may, of course, be made at any other time. A witness speaking for the first time should state their full name, the capacity in which they appear, and witnesses should speak clearly and into the microphone to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. Left intentionally blank. I now welcome representatives from the Law Council of Australia, the New South Wales Bar Association and the Victorian Bar Association. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name and the capacity in which you appear today?
Juliana Warner. I'm President-elect, Law Council of Australia.
Congrats.
Michael IZZO, Junior Vice President of the New South Wales Bar Association.
Thank you.
Fiona McLEOD. I'm here in my personal capacity in representing the Victorian Bar.
Thank you.
Stephen Stevens. I'm here in my capacity as Chair of the Professional Ethics Committee of the Law Council.
Thank you.
Murray Hawkins. I'm the Principal Advisor on Regulation and Professional Standards in the Law Council Secretariat.
Great. Thank you very much. Now, before we go to questions, I'll ask you to make a brief opening statement. We do have limited time to ask you questions today, so if we could keep those statements as brief as possible. I'll start with the Law Council of Australia. Thank you.
Thank you. The Law Council of Australia welcomes the opportunity to appear before the committee today about this very important legislation. Of course, we acknowledge the traditional owners and custodians of the land where we are providing evidence today, and we pay our respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples attending. Since I don't know if you've had the opportunity to review the fairly complex submission.
We have.
That we
You can take it as read.
Okay.
We're very, very good at reading submissions.
Thank you.
Thank you.
But I would still like to make a few opening remarks,
Correct.
which maybe are a little bit longer than we would normally do. First, there's a housekeeping matter. There's a reference on page 6 of our submissions to costs of $1.85 billion per year for the tranche 2 entities. That needs correcting. The correct figure is $1.85 billion in upfront cost and ongoing costs of $12 billion over a 10-year period. And I think we're going to be submitting an amended submission that corrects that and a couple of other typographicals. I'll now turn to the substance of Law Council's position, and first I want to deal with the role of lawyers. There is no doubt that money laundering is a scourge, and no decent, honourable legal practitioner wants to have any part in facilitating money laundering. In fact, the overwhelming majority of our profession are decent, upstanding, honourable practitioners, and we are duty-bound not to facilitate money laundering transactions. There are, of course, bad actors who turn up from time to time, and the entire weight of the law should be visited upon them. But they don't reflect the profession. We don't oppose those parts of the legislation that are aimed at strengthening the profession against unwitting facilitation, even though we understand that there will be a cost burden that goes with that. In fact, we are working very hard to upskill the profession in relation to money laundering issues. But we do oppose those parts of the legislation that we think will impact on and undermine the very important role that lawyers play in supporting the rule of law. We perform an important function. We are different to any of the other professions who are going to be caught up in the regulation of this, or any of the other entities. We are Office of the Court, we underpin the judiciary, and we owe fiduciary duties to our clients. We're bound by a comprehensive set of ethical conduct rules which are backed by statute. As part of our Westminster system, the judiciary is institutionally separate from the legislature and the executive, and it exercises its powers. The judiciary exercises its powers to ensure that the executive and the legislature do not exceed their respective powers. The judiciary cannot function properly without legal practitioners who owe a paramount duty to the court. One thing is clear: we are not part of executive law enforcement, and in fact the criminal justice system depends upon us not being part of law enforcement. This bill would require us to become covert informers on our clients. The threshold for suspicious matter reporting is very low and broad, and is much wider than money laundering. The requirements are not just to report any serious offences, but something that may be relevant to an investigation about any offence against Commonwealth, state or territory law. Under the bill, we cannot tell our client that we've informed on us. For us to become covert informers on our client, which is what this bill would require, is fundamentally at odds with our role and our duties. And we think it is worthwhile bearing in mind what the High Court had to say about Lawyer X. And it's this: EP's actions in purporting to act for the convicted persons while covertly informing against them were fundamental and appalling breaches of EF's obligations to her clients and EF's duties to the court. There are already circumstances where, under our conduct rules, which are backed by statute, they are statutory obligations, we can disclose. And that is where there's a probable commission of a serious offence, and that's for solicitors, or where there's a threat of imminent physical harm, and that's barristers and solicitors. But there's no requirement to do that secretly. This is quite different to what's being required by Section 41. Under the bill, anything that goes to AUSTRAC can go to other agencies, and in fact that is the purpose. They want to be able to distribute to other agencies. There's carve-out for legal professional privilege, but we don't think that solves the ethical problems that legal professionals will face, because many things are highly confidential but not privileged, and they would have to be disclosed. Information that may be privileged might not be properly presented because lawyers can't get instructions about it, so they can't, because of the tipping off provisions, tell their client. They might not be able to make a proper assessment, and errors may occur and things will slip through the net. If an error is made, privilege is lost, and it can't be retrieved because it's gone to many different agencies. And the process that is being proposed, which is the LPP form, preempts a review that's being done at the moment between Treasury and the Attorney General's Department about how to deal best with LPP in the scheme, in the context of a whole raft of different legislation. Also, there's another problem with this, which is that the arbiter of privilege appears to be AUSTRAC, and that is just untenable. This should really be dealt with by a court. That's why we say that there needs to be a carve-out for lawyer-client confidentiality as well as legal professional privilege for suspicious matter reports. And the same reasoning applies, frankly, to the notices, not the notice of provisions, because you put the lawyer in the position with a notice where they've got to try and answer it without being able to tell the client, without being able to take instructions, without a retainer, without being able to ask the client to pay for it, for example. Even a major global firm would have trouble struggling to do that. But we're talking about basically a profession of sole and small practitioners in the suburbs and in the regions. How could they possibly deal with that? Now, we have been told that there's a lot of concern about FATF, and I'm sure you're going to hear a great deal about that today. We think there may be substance in that if what we were talking about was excluding lawyers entirely from the regime, but that is not what we are talking about doing. What we are talking about doing is in relation to the reporting part of it, not that part of it that involves strengthening the profession against facilitation. And we also think that on a careful reading of the FATF requirements, the exclusion of reporting by lawyers is left to the domestic policy of individual countries. And individual countries have adopted different positions. New Zealand only excludes legal professional privilege. The UK excludes legal professional privilege plus some other confidential material. And Canada excludes all reporting. We think we should adopt the Canadian model. And Canada has not been grey-listed by FATF. We think that that model, which involves the strengthening of the profession, but at the same time not undermining the reporting, the role that lawyers have in representing clients and in defending clients against upon occasion the state, it's really important. And that balance is we think, correct there.
Ms.
Now,
Warner, I'm going to have to ask you
barristers,
and so I can give your colleagues an opportunity to also give opening statements.
I'm going to let barristers talk.
Yes.
There's one more point I would like to make.
Of course.
And that's in relation to, in fact, there's two very quick points. One is in relation to costs. Our first recommendation is actually that we have a review of this bill in 3 years' time, because we don't know what costs are going to be involved here. We don't know what the impact is going to be on the profession, and we think, or indeed on business. So we think that's important. The last point I want to make is that there are some very surprising provisions in relation to the abrogation of the privilege against self-incrimination, which need to be looked at very carefully. And now I'll let them get a word in edgewise.
Thank you very much. The New South Wales Bar Association, thank you.
Thank you, Senator. The committee has the two-page written opening, and I'm not going to read that out, but I'll just explain what the point that is raised by it is. And it's a specific matter concerning the application of the AML regime to barristers and ultimately the impact on access to justice. And the point is this: the Attorney General's Department takes the position, which is confirmed in the submission that they served last night, that a barrister who is instructed by a solicitor will not be subject to the AML regime. We embrace that approach, and we agree that a barrister in that situation should not be subject to the regime, both because they have no direct relationship with the client and because the solicitor has to comply with the regime anyway. The problem is this, that if you look at the wording, and in particular Table 6, it doesn't achieve that outcome. And the reason is that Table 6 uses a formulation that talks about a professional who assists or otherwise acts for or on behalf of a client in a transaction. And the difficulty that language presents is that that is going to capture barristers who provide advice for the ultimate benefit of a client, notwithstanding that they're instructed by a solicitor in respect of that transaction. It's also going to catch barristers who go to court for a client, again on the instructions of a solicitor, where the court proceeding is necessary to effectuate the transaction. And the simple point is that the drafting as it is doesn't achieve the intention. We think there needs to be express drafting to clarify that the Act operates in the way that the Attorney-General's Department says it is supposed to operate. And we're concerned that if that doesn't happen, then the difficulty you're going to have is first that compliance costs are incurred twice, first by the solicitor, then by the barrister. All of that gets ultimately passed on to the client. And secondly, that a lot of barristers are just not going to be set up to do this work and won't be able to do it. And where barristers are sole practitioners and normally don't employ staff, there's a real issue about whether it's feasible for a lot of barristers, particularly in areas that don't generate enormous amounts of fees, like family law, criminal law and advising small business. There's a real issue as to whether they're going to do that kind of work as opposed to taking the other work that's available to them. None of that is good for access to justice. So we very much press on the committee the need for express drafting to address this issue, and we're more than happy to assist the committee in doing that.
Ms McLeod, did you want to make
Yes, I
an
do.
statement?
Pardon me. Thank you, Chair. I'm very grateful for the opportunity to appear this morning. Could I refer senators to my short personal submission, which is number 14, and also the Victorian Bar submission, number 34. I acknowledge we're on Ngunnawal country and pay my respect to ancestors and elders. I want to address particularly the position of barristers under this bill. Some years ago, I was President-elect and then President of the Law Council when Tranche 2 considerations came before this Parliament on the last occasion. I'm also a former chair of the Open Government Forum and Transparency International Australia and know many of you in my role campaigning for integrity measures, including the National Anti-Corruption Commission. I think we don't have the balance right. And my submission today is essentially that barristers should be exempt entirely from the operation of this Act. Barristers have not been distinguished from solicitors in the manner of their practice or the risk assessment in the AUSTRAC submission, the submission from the Attorney-General's Department, the FATF horizontal review of gatekeepers, technical compliance, or any other risk assessment undertaken that underpins this legislation. For very good reasons, barristers were to be exempt from the operation of the Act when they were last considered in 2016-2017, and the Attorney-General's Department consultation paper, published in May this year, noted the work undertaken by barristers, as well as general advice on matters such as directors' duties and employment laws, would not be captured. From that assurance, we now see the supplementary submission sent last night of the Department. The FATF 2019 guidance note identifies barristers as part of the definition of legal professionals and goes on to say if they conduct designated services, they would and should be captured by the regime. So first I need to note that the reference to barristers in the 2019 FATF guidance note for legal professionals is simply a taxonomic grouping. It does not support the substance of the AGD's supplementary submission about intentions. In some countries, barristers do not practice at independent referral bars as we do here in Australia, and barrister is simply an honorific or a term referencing someone who has joined a bar in the United Kingdom, for example, and then returned home to practice in a firm. Countries such as Malaysia, Singapore, Bangladesh, Pakistan or other former Commonwealth nations adopt this nomenclature. The guidelines do not in any way assess the money laundering risk of barristers relevant to our practice in Australia as members of independent referral bars. Last night's submission goes on to say the intention is to capture barristers performing designated services, but then says barristers acting on instructions from a solicitor on behalf of a client are not intended to be captured. But as the various bar submissions to this committee note, the drafting does not affect that result, leading to inconsistency. So we have to get this right. There were and are good reasons for the position that barristers should be exempt. Back in 2016 and 17, when we first looked at tranche 2 and the cases supporting the introduction of tranche 2, and now. The current draft does capture barristers' work when we consider broad definitions of designated services. I just want to restate briefly, very briefly, why barristers' work should not be covered. First, barristers are not gatekeepers. We do not and are not permitted to handle client money and conduct transactions or do any other relevant thing, and we present low to zero risk. It is ludicrous to say we might do so, so we should be regulated, just as it is ludicrous to suggest that people who publish real estate advertisements should also be regulated. No case study identified in the AUSTRAC report or previously identified by government agencies to the Law Council involves a barrister. And I haven't come across another FATF common law country where a member of an independent bar or barrister's work is considered anything other than low risk. That is reflected in the Borough of England and Wales guidance note to its members, repeating the fact of that low risk in multiple places. So to regulate barristers is inconsistent with the stated methodology of applying a risk assessment approach. Secondly, as has been noted, barristers, like solicitors, are officers of the court. Our role is fundamental to the proper administration of justice, and unlike other professionals and unlike many other lawyers across FATF countries around the world, we are already caught by oaths upon admission to practice, certified ongoing fitness of good standing, duties of honesty and our overarching obligation to courts, our codes of conduct, show cause processes, ethical oversight and regulation. So there is simply no need for further regulation. And I pause here to make the point, yes, I'm watching the time.
I'm going to wrap you up because we have to go to questions. I'm sorry, we've got 3 senators waiting to ask questions and only 15 minutes.
Can I just make these 2 points then?
Very quickly?
Yes. The High Court, if the real intention here is to have barristers available as sources of information for law enforcement agencies, as the Law Council says, that is a fundamental and appalling state of affairs, and one doesn't need a crystal ball to predict what the High Court will make of it. We don't have the primary relationship with the client, and these changes will impact upon the delivery of services critical to access to justice for many Australians each year. So we need a blanket exemption, and I can certainly happy to assist with the options for how we draft such exemption, including as a regulated service or designated services.
Thank you. Senator Scarr, you have the call. You might be on mute still, unfortunately. No, we've got you there. Thank you.
Yeah, thank you, Chair, and thank you for the witnesses. I'm sorry we've only got 14 minutes left to ask questions, but please rest assured we've got your submissions, and I think you all made your points extremely well. So I'll just make that point. If I could ask first if the Bar Association of New South Wales and the Bar Association of Victoria, Ms McLeod, if you could, if we could take, or I could put a question on notice asking you to provide some drafting which you think would address the issue in relation to capturing barristers. I think you've made a very cogent and strong case, but if I could ask you both to submit some wording which you think would close out the issue, address the issue satisfactorily from your perspectives. Are you able to do that?
Certainly, for our part, we're happy to.
I'm certainly happy to do that, and you'll see in submission number 14, my personal submission, I've offered some suggestions about drafting, but I'm happy to supplement that.
Well, and to the extent that were provided by the Bar Association of Victoria in its capacity, that would perhaps give it added weight,
yes.
Ms McLeod, as well.
Yes, thank you, Senator.
Okay, thank you. I'll go to the Law Council of Australia now. I am interested to know is there an understanding within the Law Council of Australia, within the profession, as to what the imposition of these obligations would mean practically on a small practice, 1 or 2 member practice, which have, as you've said, the majority of legal practices have 1 or 2 partners. Does the profession have an understanding what they need to do practically in order to discharge their obligations in the event that the bill was passed in the form as presented?
If I could say, I think it is dawning on the profession the full extent of what might be involved here. There is a great deal of bureaucracy and sort of paper and documentation that will be involved here. There is undoubtedly cost involved in having to seek specialist AML advice, for example, in risk assessments and the like. We are working very hard to get guidance out and understanding out into the profession about how best to manage these obligations that are coming, but it is undoubtedly going to impose a real burden on very small practices, and that is of concern because so many are in the suburbs and in rural and regional areas.
So, to be frank, it concerns me when I hear a leader of the profession say, or give the answer that you've just given in terms of it is just dawning as to what these obligations may mean. But, before this bill is passed, if it is to be passed, I would have thought we should be quite clear as to what this means for a legal practitioner, say, and indeed a real estate agent and accountant in terms of their day-to-day operation. What would they be required to do after this bill is passed, which they are not required to do now? Do we have any
We haven't seen the rules.
Clarity with respect to that?
No, because we haven't seen the rules. A significant
Okay.
part of this regime is a redraft of the rules, which has not yet occurred. It is a process that will be undertaken over the course of the next 12 months, basically.
Has there been detailed consultation, coordination between the profession and the department with respect to what may be in those rules or not in those rules? Is there any transparency or insight in that regard?
Not a great deal. There have been discussions with AGD, but it's really still in the formative stages to work out precisely what is going to occur. Take, for example, a real estate transaction where there are many different people who would be involved in a real estate transaction. Are they all supposed to be doing CDD? Is everybody supposed to be doing PEP and sanction screening? Or is there going to be a way of relying upon someone in the transaction to do the PEP and sanction screening? So there's a lot that is still out there to be worked out as to what it's really going to mean on the ground.
Can I add to that? Sorry, Senator, I was going to add to that answer. Barristers, of course, are sole practitioners, and we practice individually. The burden on barristers individually is not only a double burden if the solicitor or other referring entity is already complying, but it does create a significant burden when somebody is required to know their client and they don't have the direct relationship and report as set out under this Act. And how does that apply when somebody is appointed as a mediator, appointed amicus curiae, or appointed by a court to conduct a matter under a pro bono referral system? There are numerous examples where there is a lack of clarity about how barristers will be affected in terms of the compliance regime.
But, Senator, it may help to understand the context of your question by noting that solicitors do client due diligence day in and day out. It's part of their job. They have to know who their clients are. They have to know their client's circumstances. They have to know what their client wants to achieve. They have to know why their clients want to achieve, and they have to make a judgment about whether that is lawful and proper, and if they're not satisfied, they have an obligation not to provide legal services. So that's a broad way in which the job of a solicitor currently is.
But that doesn't mean that there's not a lot of prescription involved in preparing a risk assessment, doing a risk assessment of particular customers, understanding what might be involved in that. So there's a whole layer of complexity which is still to come, which is where the additional cost comes. And that's why we say this needs to be reviewed in 3 years' time to see what has actually transpired.
I think you've made that point extremely well. In terms of this issue around suspicious matters reports, I note that the Supreme Court in Canada struck out that imposition on the legal profession, and thank you for providing the extracts from the judgment in that regard. What are the learnings from the UK in terms of the imposition of these obligations?
The UK has a slightly different regime because reporting is done to the Solicitors Regulatory Authority rather than to the financial people. It's a different measure of a different definition of what actually has to be reported. It's not as wide as the suspicious matter reporting obligation here. Anecdotally, we understand that there are still difficulties for solicitors in trying to figure out what on earth they're supposed to be doing and how they deal with the ethical problems. And in fact, I had one advisor say to me, you get a solicitor who's caught between a rock and a hard place. There's a very high penalty or there's breaching your fiduciary obligations. What do you do?
Can I add to that? Our understanding is that in respect of the UK, there's two key differences to the proposed regime. First, the suspicious matter reporting is confined to offences involving money laundering and terrorism. That is not the scope of Section 41 of the Act, in fact, as it now is. And Section 41 of the Act imposes the suspicious matter reporting obligation in respect of matters that might be relevant to an investigation of an offence against a law of the state or Commonwealth. So or territory. So it's extremely, while we're all here because there's an act about money laundering and counter-terrorism financing, Section 41 is not so restricted. So that problem doesn't exist in the UK. The other difference in the UK is that it's been made clear that the obligation doesn't apply to barristers if they're giving advice on specific aspects of a transaction, and that, as you understand, is one of the key concerns that the New South Wales Bar has raised, that the legislation, the proposed form, would catch that kind of work.
Okay,
Senator Scarr, I will have to share the call if you've got one more question, and then I can hand the call to Senator Shoebridge.
Well, I'm interested if, just to put on notice, perhaps for the witnesses, if they've got any further observations or details with respect to learnings or differences in approach, particularly in the UK, but in other jurisdictions that are comparable, so we can consider those. I personally find that useful. But thank you very much for your submissions. There's so much work that's gone into them. I found them extraordinarily helpful and compelling. So thank you.
Could I please just add a third difference with the UK briefly? There's going to be, under the Australian regime, a lot more of an obligation to report suspicious matters because the only exclusion is for situations where all the information is subject to legal professional privilege. In the UK, as well as excluding a reporting obligation for legal professional privilege matters, there's an exclusion from reporting for other confidential information described in the UK legislation as information obtained in privileged circumstances.
Thanks. Senator Shoebridge, you have the call.
Thanks, Chair. I probably should first of all indicate that I remain a member of the New South Wales Bar Association and retain my practising certificate. So I indicate to the extent that that's a an interest that I have in the matter. Could I first of all, we just don't have time to go into detail, and I'm sure we'll be interested to see what each of you say in relation to the UK model and differences between the UK models. If you've all taken that on notice to Senator Scarr, I look forward to that response. Could I ask the New South Wales Bar Association, is one of the rationales for having barristers excluded is the due diligence has already been done by instructing solicitors. Have you considered perhaps having an arrangement in place where if you satisfied yourself that the due diligence had been done by the solicitors, that would satisfy your obligations under the regime, and amendments to that effect?
It's certainly an approach. The difficulty is that it's very difficult for a barrister to reach that state of satisfaction without having some independent understanding of what the solicitor has done. And it arises in this way that a lot of the time barristers are consulted in respect of these kinds of transactions in a very ad hoc fashion. So you could have someone come up for an hour to have a conference about what a particular clause looks like. And barristers do that kind of advice work frequently. And the capacity to form a view as to what a solicitor has done in respect of each one of those situations is very limited when you just don't have that insight. And it's not going to go very far if you just accept the solicitor's word for it, because then you'll be criticised for doing that.
There's solicitors' undertakings, of course, but it's got the same problem.
But it's got if there's a defect, you're caught by the defect.
I'm caught by the defect too.
No, but if the some form of warranty, that you could accept some form of warranty from the solicitor, which would at least require you to turn your mind to having got the warranty, but it would be self-defeating if that system then required you to independently satisfy yourself as to the thoroughness of the solicitor's provisions, but some kind of warranty basis. Or the like from the solicitor, which would at least require you to turn your mind to it, having been satisfied, being provided with some kind of assurance, adequate insurance from the solicitor, you could then proceed to give advice. That might be a sort of halfway house.
Quite. I understand the point. I suppose our reaction to it would be that it's difficult to see that it adds a lot of value to the regime, because the barrister is then you're still dependent on the solicitor to do their job.
Well, but I mean, as I understand it, your submission and that of the other bar councils is that that's an entirely adequate position to be, that the obligation should lie with the solicitor. I mean, I've got to tell you, I'm troubled by the scale of the carve-out proposed by the Australian Bar Association. That seems to go A, well beyond barristers, and B, to potentially be a sort of an undermining of the entire scheme. Could I ask you, and I might also ask the Victorian Bar, to take on notice if some kind of response to that is a potential way forward?
I understand the point, and we can consider that. Thank you, Senator.
From the Law Council, one of your primary concerns is being able to actually inform your client if a referral is required to be made, and you therefore get caught in a terrible ethical bind. And I understand that, and you set it out in your submissions and in your opening address. Of course, against you is the argument that if you tell your client that there's been a referral and your client does have in possession money that's been laundered, that will of course tip them off, and it'll be, converted to Bitcoin and taken out of the jurisdiction quicker than you can say, I got my money from drugs. That's the reason to not have the disclosure. What do you say to that?
It's a balancing exercise. It's a question of balancing access to justice against law enforcement. We do it all the time. In our view, we speak from the access to justice point of view, the fiduciary obligations, the duties to the court. Sure, you can legislate the fiduciary obligations away, but I don't think you can wash away the duties to the court. As my understanding as a practitioner of 40 years standing. Now, in relation to I can't think of a way through that a practical way through that at the moment. There will be some kind of practical way through.
But again, it may be that there are elements of the UK model that would be worth looking at, and if you could address that in your answer on the UK model, that would be incredibly helpful. One of the other options would be, again, potentially saying once you make a referral, you give a reasonable amount of time to AUSTRAC and whoever they share the information with to undertake some investigations and potentially put in place a freezing order if they need it. But then after a period of time, you're entitled to inform your client of the referral. And I don't know what a reasonable amount of time is. Maybe it's a month, maybe it's a fortnight, which would again potentially be a way through this.
That is the kind of the kind of proposal that I actually think would need some serious consultation and would actually take time and couldn't properly be dealt with on notice. It's different to understanding what the UK system might be right now, but understanding what the consequences of that might be takes a bit of thinking through. And if it was something that the committee thought was something that should be pursued, then the answer may be to defer implementation or defer the passing of certain parts of the legislation until there's been consultation about that. That would be a way that would involve a better way of dealing properly with the situation.
First of all, I don't pretend to talk on behalf of the committee. And secondly, if we were to consider something like that, we'd need some assistance from witnesses.
Of course.
So any assistance you could provide in that regard would be useful.
We're happy to assist on that. Yeah. But look, at the end of the day, I'll just make the point that our judicial system, our system of rule of law in Australia is based on the importance of promoting the rule of law, promoting the observance of the law and the important role that lawyers have in that. And that depends on encouraging and giving the public the opportunity to seek legal advice on any matter, whether it's a dodgy client or not a dodgy client. It's really important that people go along and seek legal advice in relation to legal issues, because that is the best way, and that's how our system operates, to encourage people to know the law and to follow the law. Yes, sometimes people don't follow the law, but it's important that they get advice. Now, if the situation is that we sort of bring this bill in and require suspicious matter reportings, particularly very limited exceptions, then we're going to create an environment where people are going to be in a situation where they're not going to frankly seek advice, or not going to be frank in seeking advice if they do seek advice, or they're going to shy away from seeking advice. They're not going to be interested in seeking advice. We're going to discourage people because of the fear that they could be covertly informed upon by their lawyer. That's going to really affect the Australian legal system from what the objective is at the moment. Lawyers are officers of the court. Our duty is to promote observance of the law, and our system relies on us encouraging, as a community, people to seek legal advice. And if you are in fear, even if whether you're a dodgy client or not, if you're in fear of disclosure covertly without knowing about it, then that's going to discourage people. We need to balance whether that's an important consideration. I don't think that's been taken into account in terms of suspicious matter reporting. So, as Juliana said, we support the introduction of these measures of the application to lawyers, but there are significant issues, particularly suspicious matter reporting, which we strongly oppose, and we ask that that be considered. And if necessary, based on your proposal, we're happy to look at the deferral whilst it's further considered.
Have any of you obtained advice about potential constitutional challenge or the advice on the application of the Lawyer X principles? Have you obtained some advice on that, given the High Court's observations in the Lawyer X case? And if so, could you share them with the committee?
I'm not aware of any advice on that, Juliana, but I just make the point that the Lawyer X case that Fiona referred to stands clearly on its all four squares. It is a gross breach of the duty of a lawyer to the client and the administration of our judicial system in Australia to covertly inform on a client.
No, I understand
Senator
that.
Shoebridge, I'll have to wrap you up in a second.
We can provide you with a note about that. It's probably not a constitutional issue, but more a fundamental protection of the common law. Yep.
Yeah, that seems to me to be one of the issues. If the legislation is vulnerable to challenge based on the principles the High Court enunciated in that Lawyer X case, actually having that articulated to us in a compelling opinion or the like would actually be of assistance. I think would be of assistance to myself, and I assume would be of assistance to the committee. So, and I assume it wasn't just a throwaway comment, Fiona. It was a matter of some consideration. That consideration would be useful.
Senator, can I add that point is addressed in some detail in the New South Wales Bar Association's submission, and while we don't have something that I would formally call an opinion, I can assure you that that submission has the input of several very distinguished barristers, and the difficulty is the fundamental point the High Court identified, that particularly in the criminal justice system, but even more broadly, you can't act for someone and inform against them at the same time. The law might make you inform against them, and it can do that, but then you can't keep acting. Yeah. And the difficulty is, how do you stop acting?
How do you stop acting without doing the tip-off?
Exactly.
If you have that ethical divide, that defeats the very purpose of the confidentiality. If you just mysteriously stop acting and you say you can't explain why, it's kind of like putting a red light on it, isn't it?
Oh, well, this happens in the real world where people are in court, where a court is going to want an explanation, where a regulator is going to want an explanation, where the client and the opponent are going to require explanations. So it's not like another professional services advisor ceasing the provision of services. It can have quite a dramatic impact, particularly in the criminal law.
Public.
Thank you, Senator Shoebridge. Thanks very much. Appreciate it. I will also be very brief with my questions. I'll come to you in a second, Ms Warner. Of course, if there are additional information that you want to take on notice of the questions asked by the previous senators, please feel free to do that. Going back to, I guess, the tranche 2 provisions, there's been reviews since, I think, going back to 2015, foreshadowing the inclusion of tranche 2 professionals in the regime. The most recent was the 2022 review from this committee in the previous parliament. As I understand it, your submission provides support for the general proposition of the inclusion of tranche 2 professionals. Is that right?
Yes, in general terms, yes.
Yeah, okay. And you said in your opening statement that legal professionals, of which I am one, are duty-bound not to facilitate unlawful transactions. Of course, there are bad actors and that they deserve the full weight of the law, but bad actors don't reflect the profession. Have you read the AFP submission?
I have.
Okay.
I have.
The AFP submission outlines, I guess, their experience with money laundering and policing money laundering and detection of that type of criminal activity. And in their submission, they observe that that more often than not, tranche 2 entities are actually unwitting facilitators or reckless to the risk of money laundering or concealing proceeds of crime. So they identify that it's not necessarily bad actors, but actually where legal professionals are unwitting facilitators or reckless to the risk.
Because they don't.
Sorry, I'll put my question to you and then you can answer it. Do you think that the regime that's being put forward will actually support and strengthen legal professionals in mitigating against these risks that have been identified by the AFP?
Well, not by itself, but allied with the education program that the Law Counsel and all of the constituent bodies are putting in place to roll out. It is really important that people understand what red flags look like, that they... I mean, it's quite complex working this out. I also think that it is important that this is now taught in law schools and in PLT courses and the like, so that people know when something is trying to be put past you. That is the real part that will stop unwitting facilitation. All of the bureaucracy that goes with it is, to my mind, just focuses the attention more on the need for better education out there for the profession, which is what we're trying to do.
Yep. Okay.
And this is an evolving process. To the extent that the legislation will enhance customer due diligence, that's an important development, but it's not the start of the point. The profession has been involved in educating the profession since 2011. The Law Council has published material guidance for legal practitioners on anti-money laundering and terrorism financing risk issues and checking against it. And the obligations of lawyers are and always have been to only follow lawful instructions, which means you need to go and find out what is your client doing, where are monies coming from, where are they going to, what's the reason, and if you suspect there is something illegal, then you have to cease acting. That's your obligation currently. Earlier this year, the Law Council put out expanded and very detailed guidance notes on anti-money laundering. We've been moving to do that before the introduction of this bill. It is an evolving process, and to the extent that the bill leads to enhancements to customer due diligence, I think that is important, but it will be an evolving process, and as you can see from FATF, they're changing some of their standards as well. So we need to do everything we can to deal with these scourges, and the Law Council and the legal profession in Australia has been actively involved in doing that, and there's a lot of education going on at the moment about that.
Thank you.
So, Senator,
can I just need... I'm sorry, we have very limited time and there's a few issues that I want to give you the chance to go back over, particularly legal professional privilege. The bill does actually propose a complete protection for legal professional privilege, and you outline really significantly in your submission and your opening statement around that, how that might be improved. I just put to you that some of the submissions that we've received and some of the witness evidence we'll receive today actually suggest that carve-out that the government has included in the bill significantly lowers the effectiveness of the regime. I'm just interested in your views about why the carve-out should exist, perhaps for people who might not necessarily understand how legal professional privilege operates at the moment.
You would completely undermine confidence in the legal profession if legal professional privilege was not respected. It is fundamental to the justice system. I've read some of the submissions that suggest that, but I mean, this is not all about law enforcement. This is about living in a democracy where the interests of access to justice are appropriately balanced with the interests of law enforcement.
So it's not just a matter of self-interest of lawyers.
No.
This is fundamental to the delivery of just outcomes for clients, Australians, but also the proper administration of the courts. So it's fundamental, and that's why it's recognised in numerous pieces of legislation that legal professional privilege is protected, and you can't rely upon a disclosure of legal professional privilege to do various things. So in this Act is consistent in maintaining that legal professional privilege with numerous other Commonwealth, state, territory pieces of legislation.
I would add, for any such doubter of the inclusion of legal profession privilege exceptions in the legislation, one only needs to refer to FATF itself. FATF is not saying that legal professional privilege should be abrogated. In fact, it runs the very same argument, that it's an important component around the world of our system of administration of justice and rule of law. So it's just that is really a fanciful suggestion that it's an appropriate measure. FATF itself is saying there should be a carve-out for legal professional privilege and professional secrecy,
which is wider,
yep,
as we understand it.
Just on the matter of the drafting around the exclusion from barristers, we've received that additional submission now, so we will put those questions, I think, to the Attorney General's Department this afternoon. I am interested in the question that Senator Scarr put to both of you around how the drafting might overcome that lack of clarification. Yep. Can I ask, are there many instances where barristers would be directly briefed, and how would that would the exclusion that you're seeking or seeking to clarify, would it also relate to direct briefs?
It wouldn't, and the approach that we've taken is that we at least, I think New South Wales Bar have understood the intention which we're told that the Attorney General's Department holds, and we're simply trying to make sure that that intention is effectuated. We accept that even if one approaches the matter the way that the Attorney General's Department wishes to, that direct briefing would nevertheless be caught by the regime. That's a different matter, and it's a matter that Ms McLeod has addressed.
A portion of all bars do direct briefing in criminal law matters, which is seen as a very cost-effective way to provide advice and appearance support to lower courts in small matters. Our conduct rules require us to insist on a solicitor in appropriate cases. So barristers are already required to insist on solicitors where the case warrants it. There are numerous cases where tax lawyers, for example, are briefed directly by accountants. Planning barristers can be briefed by town planners. There are cases of government lawyers who don't hold practising certificates. That's most of my practice is government work.
And the accountant direct brief is the one that may have come up in some of the examples that the AFP has given us, and that's why I asked the question around direct briefs, not necessarily from clients, but from accountants.
Exactly. So, and there's a range. So, for example, if you practice in native title work, you might have a direct brief from a prescribed body or from a philanthropic organisation. All of those potentially have a designated service involvement because of the nature of the advice that's been given. Mediators don't have a briefing instructor. They're engaged by both parties, and barristers perform mediation work. They don't have any... In all of these cases, there's no engagement with property or transactions. They're not handling cash.
Thank you. We are running hopelessly over time, but I wanted to fully ventilate as best as we can this morning those issues with you. Thank you very much for your very lengthy submissions and your opening statements. And if there are questions on notice, we'll give you a date to return those to the committee. And thank you for your participation in the consultation that led up to the bill itself. That's all the time we have.